Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. Today's topic is, how do I comply? The DOJ's new policy to incentivize corporate compliance. Companies have more and more focused on trying to avoid risk, and one of the best ways to avoid risk is to never encounter the risk at all. It's an important social value that I think the government wants to promote. And recently, there have been some interesting developments where there's been some guidance on how companies can try to do even better by avoiding those problems in the first place. Today, we're going to learn more about that. My co-host today is Wendy Waszmer.
Hey, John. It's great to be back.
Hi, Wendy. So, Wendy, what do you have lined up today?
I'm so excited to introduce our two guests today. We have two superstars from the DOJ Antitrust Division's criminal side. Richard Powers, who is currently the Deputy Assistant Attorney General, aka DAG, for criminal matters, and T. St. Matthew Daniel, who's counsel to the Assistant Attorney General, also working on criminal and other matters.
And what are we hoping to accomplish today?
So we're hoping to give our audience a little bit more background on what corporate compliance really means. That word is thrown out all the time in a way that's frankly relatively vague. And the DOJ has issued some guidance that is trying to make more specific. What do you have to do to actually show enforcers or to get out ahead of problems? And so we'll talk today to hopefully introduce to the audience more concrete concepts about what it means to actually risk assess and show that you care about corporate compliance and have the spirit of compliance within your company and with individuals.
So it used to be that compliance meant we'll do some training and we'll have somebody just do a sign-in sheet, and now we've done the compliance. It sounds like things are changing a little bit. So maybe we should bring in our guests.
Yes.
T. Richard, welcome to the program.
Well, thank you, and thanks for having us here. It's great to be with you and be on a podcast with Wendy Waszmer, who's a former colleague and supervisor of mine, actually, from previous days at the Antitrust Division.
Well, maybe
way exceeded me in any career path.
And maybe we can talk a little bit about the end about Wendy's supervisory skills. Well, let's kick off.
Yeah, so let's start out. I think sometimes when we talk about corporate compliance, it's not clear to everyone what violations we're talking about. So maybe, Richard, let's start out with you. When we talk about corporate or individual compliance at Antitrust Division, criminal side, what are the kinds of violations that companies and individuals need to watch out for? What are they trying to avoid doing?
Sure. So the Antitrust Division obviously has the two main programs, the civil and the criminal program. On the criminal side of the house, we're focused on criminal violations of the Sherman Act, which fall into three categories: price fixing, bid rigging, or market allocation. In terms of who we have that prosecutes these cases, we have 5 offices, 2 here in D.C., 1 in New York, 1 in Chicago, and 1 in San Francisco, with about 100 total prosecutors who prosecute these crimes. At the end of the day, we always say kind of the heart of what we're looking at are crimes based on agreements, right? And the agreement's the crime. And so we encounter a lot of different fact patterns, and every case is unique, but it's a very interesting and keeps us on our toes.
I mean, in terms of violations, maybe, T, give us some sense. Past cases, what are the kinds of agreements? Is it chats? Is it faxes? I know at one point we had fax paper. There was agreements about that. What are the kinds of fact patterns the division has seen in past cases?
So it's just about anything you can imagine. Honestly, if people can sell it, they can probably price fix or bid rig or allocate customers for it. So we've in recent years we've had cases price fixing of say promotional products, customized products, think wristbands or temporary tattoos. We've also had price fixing and bid rigging of auto parts. We've had bid rigging of foreclosed auction properties. Recently the division had a case involving fuel supply to U.S. military bases. So it runs the gamut. If people can sell it, they'll figure out a way to price fix it.
And are you seeing, just to give some context, when you see violations, is it companies, and are you seeing individual people reaching out and calling competitors, or what's the nature of that relationship in terms of companies and individuals?
Well, so our crime requires people. So it's, we may talk about a company being involved in an antitrust investigation, but it's the people that actually reach the agreements. And when we talk about agreements, we don't mean, I sat down with you and we wrote out a contract. It could be that, but more often than not, it's just we're looking for the meeting of the minds. And so it's any way that I convey to you or you convey to me that we have an understanding about how we're both going to compete. And that's what we're looking for.
And I think, T, what you just said is so critical, I think, to our conversation about compliance, because it's not these amorphous entities. It's really the people within a company that have to know, hey, don't reach out to your buddy who you used to work with and give him or her a price, or don't be sending an email or text message or go, quote unquote, offline and say, hey, give me some market color. So I think that individual aspect to it is really critical. So now on compliance, DOJ issued some guidance that tries to, I think, define and give some details about what compliance is. Richard, maybe you can give us some sense of, from DOJ's perspective, what does compliance mean? Like, what are companies doing to show that they are trying to do risk assessment? What are the steps that your guidance talks about to show that companies can be compliant?
Sure. So, I think compliance really can mean a lot of different things when it comes to a company. It depends on the size of the company and what their businesses are, right? So compliance, for example, for a large financial institution might be different than compliance for a small construction firm. And so, what we're focused on now and what our guidance is focused on is compliance as it relates to antitrust violations. So, we're focused on, what companies are doing to prevent these types of violations from occurring, to prevent the price fixing or the bid rigging or the market allocation from occurring. And so in terms of what we've done, we've sort of made a change recently. Back in July, we made our announcement that going forward, we would give credit for compliance at the charging stage, and we made some other announcements that I'm sure we'll talk about a little bit more later. But one of the things we did was we made public our guidance to our prosecutors for what they should look for when they're assessing a corporate compliance program. And so that document is publicly available. It's on our website. It's open for anybody to see. So anybody interested can see what we're going to look for and what we're going to ask about when it comes to a company's compliance program.
So to go back to something John said at the beginning, I think when I first left DOJ, the first instances I saw of compliance counseling or compliance programs, literally a binder. Like someone would hand me a binder and be like, this is what we're doing. And, I take it, the policy that you're, or the guidance that you've put out there, and maybe, T can talk about the examples or different concrete aspects to this, but the binder isn't really what you're getting at. Is that kind of a message to the field? Don't do like the one training a year and then the binder. That's not going to cut it with DOJ.
I think what we're trying to get at is that, your compliance program is part of a bigger picture of your corporate citizenship. And so if the binder can't just be it, right? It's got to be more than the binder. You can't just drop a binder on someone's desk and say, read this and you'll be compliant, and expect that that's got to be all you do. So we want companies to sort of take a step back, think about what business they're in, what their risk profile is, and then design a program that actually gives their employees the rules of the road, right? And so just dropping a binder and saying, well, you read that, you're going to know what price fixing is and you're good to go, may not be an effective compliance program, because I think our concern at the end of the day is about deterring this conduct in the first place. So give people the information and the context so that they know what to avoid doing.
Yeah, and if I could just jump in and echo something T said, at the heart of this, and it goes to your question, Wendy, about dropping the binder, is good corporate citizenship. Because at the end of the day, let's say our mission is deterrence, detection, and prosecution. Detection and prosecution, on some level, only are of limited value in terms of preventing the conduct because it's already happened, right? And so where we are right now, sort of bigger picture, is focusing on the deterrent side of the equation. So when it comes to companies and corporate behavior, what we want to see is good corporate citizenship, and we see a real commitment to compliance as that good corporate citizenship, and that's what we're trying to get at with our recent changes.
It's a really good point. We're talking about deterrence, which I get. We talk a little bit about detection. I think we might be talking about, when you think about it from a compliance perspective, a compliance officer may be thinking about detection in a different way than perhaps the DOJ is, because I think you're looking about detecting a violation, and the compliance officer has to be thinking about detecting risky behavior that may not yet rise to the level of a violation. Is that a real distinction?
Probably. I mean, I could see where that distinction would really matter, and I could see from the company side of the house that, in terms of detection, they want to detect that risk before it becomes a full blown problem. I mean, we've talked about this change in the sense of the ounce of prevention, right, is worth the pound of cure, and the reality is, if you get caught up in an antitrust investigation and you have real exposure, there's a parade of horribles on the other side of that. And so, we think there's a lot of incentives out there beyond just good corporate citizenship to want to detect that risky behavior. But yes, from our side of the house, detection is, okay, something's happened. We've uncovered it, and now we're going to investigate and prosecute it.
Right, and we would prefer that we detect it before you detect it. Because when I say we, the corporate, I think the companies prefer to detect it first, because then they might have options that would, I'm sort of trying to be funny, but that would include self-reporting and other things.
Exactly. I mean, I think a lot of folks know that the Antitrust Division has its corporate leniency policy. And so, leniency remains the greatest possible reward for an effective compliance program, because if you are able to detect it early enough and win that race in for leniency, then you are, you're essentially, going to not be prosecuted. Executives who cooperate are not going to be prosecuted. You're not going to face the substantial criminal fines, and on the back end, your liability in any related civil litigation is going to be greatly limited and reduced. And so yeah, by focusing on detection from the corporate side, there's a lot of upside in terms of being able to self-report quickly. And then look, part of the change now is, okay, let's say you don't win that race to leniency, but you do have a good compliance program, and it enables you to get in quickly, self-report, and begin cooperating immediately with us. As we've sort of talked about with the changes, there may be a possibility of a deferred prosecution agreement. Now we can talk about how compliance fits into the broader way we think about prosecuting companies, but your cooperation, the earlier you come in, there's a better chance it'll be more valuable to us. And so, there's, even if you don't win the race for leniency, there's still a whole host of incentives out there to come in and begin cooperating early. And the last point I would make on that is, we also view that approach as a way we evaluate the compliance program and the culture of compliance and commitment to compliance. So it's its own thing in terms of the value of the cooperation, but it's also a way we look at and evaluate the compliance program.
Well, and on that point of incentives, I mean, I think one of the things that I've seen out, representing companies and individuals, is sometimes there are companies that are pretty sophisticated already, and they understand why you would engage in compliance, and they actually already have an incentive to do it. But for a company that maybe newer to the field, or like not regulated, hasn't, maybe newly public or something like that, what, with the changes in the kind of guidance, what is the incentive for them? What do they get if they, do as the DOJ is suggesting, and they engage in what sometimes, pretty labor intensive or pretty intensive efforts to try to find risk and find people and interview people? What's the kind of carrot?
So, I mean, there's a lot of carrots, to be honest, right? The ultimate carrot is the leniency program, and Richard already touched on that. But I think for companies to sort of understand that antitrust crimes, price fixing, bid rigging, market allocation, they're difficult to detect. So their best bet is to get ahead of it and try to prevent it from happening in the first place, because it's a conspiracy. So if your compliance program isn't so great, what's to say your co-conspirators isn't awesome and they don't find out about it?
And they're going to beat you.
They will beat you in that race for leniency. Right. So that's part of the thing you have to be thinking about. But then, when we made this policy change, our Assistant Attorney General gave a speech, and he sort of started it talking about fires in Philadelphia, talking about Benjamin Franklin, an ounce of prevention is better than cure. And this is literally what I think of as cartel fires, because start small. If you get it quickly, you may have a shot at leniency. You can cabin the damage. But if this thing gets out of control, we've seen conspiracies that go on for decades and decades. And your criminal fine is driven by the volume of commerce. Treble damages and follow-on civil litigation, it's just, then you end up in bet the company litigation type of situation. So I think for a company that's thinking, well, why do I need an antitrust compliance program? It really is your company. You're trying to safeguard the heart of your company. It goes right to the heart of your business. And so you can't overstate it, in my humble opinion.
Well, and to go to Richard's point, I mean, the parade of horribles that you could go through for an entity that somehow misses the boat, it's like a decade's worth of, situation. But if a company does miss the boat on leniency and they get tagged and their competitor goes in and kind of rats them out, what's the option then? If they've invested in an audit program or they've gone in, they've done compliance, what can they say to you after that and say, hey, DOJ, I still should get some credit for this because we did a good job?
Well, I think what, previously, I'd probably step back on this one too, but, previously we didn't look at compliance programs, right? So there's a couple, I would say there's probably, we'll break it down into two phases when you can think about assessing a compliance program and how that affects our decision making, right? The first is sort of the charging phase, and the second one is at sentencing. Previously, before the change back in July, we didn't consider it at the charging phase. We would consider it in the sentencing phase, and I think you could go back to 2015 and see probably 3 examples where we did provide credit with respect to the fine a company paid for what we call like a forward-looking prospective compliance program changes. Now what we do is we will look at the compliance program both as it existed at the time of the offense and at the time the charging decision is made, evaluate it, assess it, and what we're looking for is, I don't want to rehash it, but it's in the guidance document that we made public, and see, was this an effective compliance program? And if it was, one of the opportunities that's out there is a deferred prosecution agreement. And a deferred prosecution agreement, for those who aren't aware, it's sort of a middle ground in terms of our charging, what we can do in terms of charging, right? So if on the one end of the spectrum you have indictment, guilty plea, conviction, and then on the other you have maybe declination and non-prosecution agreement. A deferred prosecution agreement is a little bit of a middle ground. A charge is filed, but the prosecution of the case is deferred for the duration of the agreement, and at the end of the day we'll go in and if all the obligations are met, we'll dismiss the charges. So the company doesn't face the conviction. So that's one of the benefits. On the sentencing side of the house, we're still, we still obviously have to follow the sentencing guidelines. There is a 3-point reduction available under the guidelines. But the guidelines spell out, when you can get that, it's pretty high standard, and it's seldom achieved, but it is overall, we can consider compliance in terms of where we start a company in the range and whatnot. So it matters on both sides. So in terms of, what could it mean for a company, those are the places where we can look at it. And those are kind of the potential rewards out there. And in terms of what we will look for, again, that's, why we made the guidance document public.
So it seems like it, whereas in the prior world, it was just a little bit more black and white. If you kind of missed the leniency chance, then maybe the companies wouldn't have thought there was a reason to continue to make an effort. But here it sounds like, is it right that now there's a couple different stages where you could still try to demonstrate that you have good corporate culture and the DOJ is offering different moments in time where you could come in and actually make that argument. Is that fair?
Yeah, I think that's right. And I think that's right that, there are different points where they can come in and make the argument. I'll put like one little asterisk on this, which is, for anyone out there who's thinking, well, I'll sit back and see what happens. And then if I know I'm really, in it and I know there's nothing else to do, I'll try to come in at the end of the day and say, oh my gosh, we have a great culture of compliance and we're committed. That is I believe that will be a costly mistake because you will not get the credit in that scenario.
Right. And I think, just to piggyback on what Richard was saying, if you're in front of the Antitrust Division, then you've probably had a compliance failure of some sort. So to figure out if your compliance program actually merits any credit, is it actually effective, we're going to want to try to figure out, well, did it actually ever set up any flags? Were there ever any incidents that it actually stopped any antitrust violations or similar violations. Because if you've got a program and you say it's great, but it never has actually been tested and it's never actually worked, and you're like, but it was a really great program.
So you're saying we shouldn't have a hotline where no one answers the mailbox.
Right. You shouldn't have
Or
a hotline
an
where no
email
one knows the
line where
number.
no one
right?
checks it.
Yeah, exactly.
I have seen that.
Yes. This is exactly what we are.
It's very funny. My clients never do that.
Yeah, I know.
For sure.
And our folks are going to ask that question. If you say, "Oh, we
Right.
got this great hotline,"
Who checked it?
great. Who checked it?
Oops, yeah.
How many times did somebody call? What happened when somebody called? We're going to ask those questions.
But I think that, the focus on is it effective, right? It seems so obvious, but I actually think there's a lot, as you guys know, in the law that's very process oriented. It's like, let's do this step and this step and this step. And, the messaging I think I get from this is, look, someone needs to be asking the question of, is this going to find the perp? Like, I always say that to people, like, is what you have in place going to find the dude or lady who's actually price fixing? And if not, it's just piece of paper. So I feel like that's, at least reading your guidance, that's kind of the messaging that I get.
Right. And I think one other thing in the guidance is it sort of runs through it, but when everyone thinks of antitrust crimes, a lot of times we're thinking price fixing and bid rigging. But we shouldn't forget that, you really have to figure out what exactly the product is and what the market is that you're thinking about, because it could well be HR professionals, right? It could be wage fixing. It could be no poach or no solicit type agreement. So if that's an issue, if that's a risk for your company or in your industry, then you should tailor your compliance program to deal with that as well.
Well, and I would just add, Wendy, to your point about it being well designed. That's one of the fundamental questions, I believe, in the Justice Manual, right? Which is, was the program well designed? And so, our guidance sort of springs out of what's in the Justice Manual in terms of how we should evaluate compliance programs, and that's a fundamental question. Was it well designed? And
So I'd love to hear, I know a little bit about our listeners really like to hear about our experts and kind of their background. So I'd love to hear, T, how did you end up doing criminal antitrust or coming to the division?
So very long story. I will keep it short. So I graduated from law school and I started out at an international law firm. Lucked out, and I wound up doing actually a lot of European competition law for my first couple of years. Spent time in Amsterdam and Brussels. Did a little bit of like merger work, and then did some antitrust cartel work, I guess. But I really wanted to come back home, so I moved back to the States, and that was right before the financial crisis / Great Recession. And as it turned out, when a lot of the merger work was dying down, a lot of the cartel work was taking off. And so I found myself doing a lot of cartel work. Really enjoyed it. I like people, so document review is fun. Going through documents is great.
I'm sorry. Did you say that again?
I like people, yes.
No, what you said before that. Document review is fun.
Document review is fun because when you're doing cartel work, you're always going to think and believe that you're going to find that smoking gun. You just have to stick with it, and you're going to find that email that just blows your mind.
You and I ought to hang out because document review is fun. If that's fun,
document review
even hanging
is
out
fun,
with
but
me
people
might
are
be
better.
fun.
People are better,
Okay.
and you can't ever get your cartel story without the people. But no, so yeah, I came back to the States, actually started doing U.S. antitrust law, did some cartel work, and yeah. Then the recession finally ended. The DOJ lifted the hiring freeze. And I said to myself, you know what? It would be good to work for the good guys. And so threw my hat in the ring, and here I am.
And Richard, to you, I know some of your background, but from the way that you came up through DOJ, do you have any advice for folks who would be interested either in doing cartel work in the private sector or, becoming a prosecutor?
Sure. I came in through the honors program, so I've only sort of known life at the DOJ. But no, I think if you're interested in doing cartel work, and we do hire periodically, so we actually went through a recent round of hiring. I think one of the things that stands out are people who show an interest in the work, right? So if you're at a law firm or whatever, have you worked on white collar cases, and do you have cartel experience? That's certainly something we I would suggest to people. And then, I think in being a prosecutor more generally, I think you just have to have a commitment to public service. It's certainly been pretty much the dominant experience for me in my life between the military and being a DOJ prosecutor. And, it's something we look for. And I would encourage anybody who wants to come to the DOJ as prosecutor to be, really committed to public service, because I think that's one of the great parts of this job.
We forgot to refer to Richard as Captain Powers, which in DOJ we basically were like, Captain Powers, come over here. I mean, it's interesting what you said though, because there's a lot of interviews, as you guys know, at DOJ, where you say, "Why do you want to work here?" The person's like, "Why? I hate my law firm." So don't do that.
Yeah. Some people say I love to do document review. I mean,
I'm never going to live that down. But it's true. I love to read, and even if it's a document review, it's still reading. So.
Right.
Well, T, I think our listeners would also like to know a little bit about what they might know, what you do for fun. So tell us something that's unusual or different about yourself that we wouldn't know if we just only knew you professionally.
Oh, that's a tough one. Okay, so the way most people feel, well, not most people, some people feel about like their wine or their liquor is the way I feel about tea. So I am obsessed with teas. Like I find tea shops to go to. I buy like random tea paraphernalia. I try out different sorts of teas. Yeah, I'm obsessed with tea.
So
is that connected to your name or?
It's not. No, it's just tea is just really awesome. There's always a story behind it. There's like ridiculously expensive teas. There's really cheap teas. It's a whole culture, like a whole culture of its own.
One of the things that has saved my marriage over the years is that when I go to London, I always stop in at Fortnum and Mason, and I hope that maybe you respect me just a little bit more because I was able to do a little bit of tea.
You're good people in my book.
Yeah. Richard, how about you? What same question. Not about tea.
Yeah, I don't share T's enthusiasm for tea, but no, I'm generally, and T can attest to this, not that interesting a person. But I think the one thing people would probably don't know is I'm now I think in my 5th year of coaching my older daughter's soccer team. So pretty much in the fall and the spring, that's what I do this year. We're the Green Ninjas. So very exciting, and I love it. It's like get to go out there and get yelled at by a lot of people, and it's fun.
So, but are you the kind of coach that lets everyone play, or you actually care about winning at this point?
It's a little bit of a mix.
He cares about winning, you can tell.
No, whenever everybody get on the field, it's just, you kind of want the better players on at the end. But, no, it's great. I know that's not that interesting, but it's pretty much what I do in my free time is coach soccer and hang out with my family.
Yeah, I mean, so Richard, I've often been accused of being two-dimensional, where I work and then I hang out with my wife and family and wife and children, and once in a while I'll hang out with my wife by herself, and then I run out of ideas. Yeah. So I think we may be similar.
The only thing people who know me know this is that I'm a diehard Alabama football fan. I grew up in Alabama, so I have we have a rule in my house that when Alabama's playing, whatever I say can't be repeated because it is not fit for any kind of consumption by small children. Do
you let your family in the room while the game is going on?
Begrudgingly, but they have to wear their paraphernalia when they're watching the game.
And earmuffs, just in case?
I try to warn them ahead of time, but it kind of just, has a mind of its own.
Before we get to our last segment, I think I just want to ask you one more substantive question, if I could, which is, if people want to learn more about the compliance program and get ideas, how would you direct them? Where should they go?
I think they should start on our website. So on the division's website, there is a subsection for the criminal enforcement program, and they can find a copy of the AAG's speech sort of explaining what we were doing with compliance, and they can also grab a copy of our compliance guidance. I think that's really where I would start. It would give them a real overview of what our thinking is and perhaps give them some ideas.
Yeah, and the one thing I would add to that is that transparency and predictability are an incredibly important part of our program. And because of that, on our website, we have a lot of our major policy documents, speeches, everything's on there. So we make sure folks understand kind of how we approach these types of cases.
All right, and what we'll commit to doing is working with you, and we'll get the links to your website up on our website. So if people listen to the podcast, they can click on that and maybe learn some more.
Great.
All right, so I think now is the time we go to our last segment, which is called Our Curious Hat.
And now it's time for the Curious Hat.
This is the last segment of the show. We have a series of questions on index cards in a hat. T, can I ask you to pick one and give it back to me? Wendy, I'll give you that one. And Richard, would you pick one? All right. Oh, sorry. All right. Wendy, would you like to ask T her question?
T, what do you wish you knew when you started your career?
Gosh, why can't I pick an easy one? I guess just how sometimes, you're never gonna get to the answer. Like, there's some cases you just can't prove or disprove, and you're gonna have to be able to live with that. There's not always a clear answer, I guess, in what we do.
All right, Richard. Actually, you're gonna feel better about your question after I ask Richard his. Richard, if you were stranded on a desert island with I don't know why this would be, but with only a DVD player, and you could bring 3 movies, what movies would you bring?
Oh gosh, I would say Office Space, Tombstone, and Die Hard.
So I'm trying to
That's a really good set of movies.
But I'm trying to draw the line, and I just don't. I need to get an economist in here that can run a regression and maybe try to figure out that. Okay, and with that, I think we've come to the end of our Curious Amalgam. Thank you, everybody. We will be back next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.org. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.